Hi, this is Jared Karchner with the Northern Virginia Estate Planning Law Practice, and today I'm going to discuss how living trusts avoid probate. Most people are aware that living trusts can be used to avoid probate, but few understand why trusts are such a powerful tool in the estate planning toolbox. Although there are any number of variations on living trusts, they all require the following roles: a truster, or settler, or grantor, you'll see those terms used interchangeably, a trustee, and a beneficiary. Now keep in mind that these are differing roles, but not necessarily different people. For most living trusts, the trustor, the trustee, and the beneficiary are the same person or couple, at least during the life of the person or couple. Now at its core, a trust is an agreement between the trustor and the trustee, where the trustor transfers property to the trustee, who in turn promises to hold it for the benefit of the beneficiary. In a revocable trust, the trustor can change his or her mind and modify the terms of the trust agreement or cancel it altogether. For additional background, let's look at how property changes hands from one person to another upon the first person's death. In the first case, property can change ownership by operation of law. Examples include any property with rights of survivorship, such as a joint bank account, vehicles, insurance policies with named beneficiaries, real property held as joint tenants with rights of survivorship, a life estate in real property, transfer on death, real property deed, etc. Although there may be some necessary steps to confirm the transfer for title purposes, each of these examples pass to the beneficiary without having to pass through the probate process. Now the remainder of your assets, not counting those that have passed by operation of law, are considered your probate estate. If your probate estate is larger than $50,000 in Virginia, it'll need to be formally probated. In a nutshell, probate is the process where the estate's representative, under court supervision, collects the estate's property, pays off its debts, then distributes the remaining assets to the beneficiaries. This can be done in two ways, either by probating the deceased will or by intestate succession. Now, if you don't have a will to distribute your assets, don't worry. The state has a plan for you. Now, it may not be the one you want, but it will be the default. And this is the process known as intestate succession. Now, probate procedures are a matter of public record. Your will, your assets, your beneficiaries, etc. will all be readily accessible to anybody who has any interest. So how does a living trust avoid this problem? As I noted previously, your probate estate consists of your assets. After you create a living trust, the point is to transfer ownership of your assets into the trust. As a result, when you die, they don't belong to you. They belong to the trust. And since they belong to the trust and not to you, there's nothing to probate. The trustee, or successor trustee, if you were the trustee at the time of your death, then distributes the assets of the trust to your beneficiaries according to your directions as laid out in the trust agreement. Now here's a note of caution. The trust is just a vehicle. If you establish a trust but fail to fund it, i.e. transfer your property into the trust is not going to do you any good. Any asset that's part of your probate estate will go through probate despite your best intentions. So that's it for today. Thanks for watching, and if you have any questions, please visit my website at novaestateplanning.com or shoot me an email at jared@novaestateplanning.com. See you next time.